think it looks like people are still dribbling in, but maybe if we make a start because it's now 5 o'clock. Good afternoon, everyone. Welcome to the first in a three-part series from 39 Essex Chambers. We put together this series about contentious applications. This one is about applications in the first instance, which are appointing deputies. That's what this afternoon's session is about. Myself and Arianna Kelly, who you can see on the screen, and all of you will know anyway, we'll be talking about contentious applications at the first stage, so appointing a property and affairs deputy. I'm asked to remind you that there's a question and answer function at the bottom of your screen. Hopefully you can find it. I was going to say if you can't find it, then you can ask for help, but I think you need to find it to ask for help. So it's at the bottom of your screen. Please do use that throughout the talk, and we'll probably deal with questions throughout, but also have some time at the end for final questions. I'm also asked to tell you this webinar is being recorded and the slides will be available in 1 to 2 days on the website. So hopefully I don't see a sudden drop off of numbers, but we are recording and also slides will be available. So why are property and affairs deputyships so contentious? When we put our heads together, we were seeing far more contested property and affairs applications than we had been even 5 years ago. And we're trying to work out why that may be. I think there are sort of four areas that I think might answer that question. The first is that asset profiles, I think, amongst our clients seems to have changed massively. So we're now seeing more awards for damages, trusts applications being made, and business assets being mixed in with private affairs. So all of that raises potentials for complication and dispute. The second reason is, sadly, there's far more family breakdown that we're experiencing in the Court of Protection. And many cases involve long-standing sort of estrangements or blended families. Just the nature of society has changed over the last 5 to 10 years, I think, and therefore the Court of Protection responds and the applications we see change. And the third aspect is arguably there's more safeguarding awareness, which is positive. People are more aware of the responsibilities of public bodies to look after them. And therefore, that sometimes leads to financial issues being framed as safeguarding disputes, and those can create some need for applications in the Court of Protection. And fourth, there is institutional risk awareness, I think. As we know, public bodies are under incredible resource restraint, and banks are under far more increasing regulation. And I wonder whether those institutions feel safer if there's a deputy appointed, even where there isn't a legal necessity for them, because it passes the buck, as it were. But in any event, against that backdrop, we have seen an increase in contentious applications for deputyship, hence this talk. Against that backdrop, also, it's important to remember that the court's starting point is per the section 1.6, which is one of the principles of the Mental Capacity Act. The deputyship is meant to be a last resort. So it must be in the person's best interest, but also the least restrictive option for them. That's usually recited in a standard deputyship order, but also needs to be remembered and sort of will come into its own when we talk through some of the issues that we find in applications. Much of today's talk will be about talking about the complications and navigating the tensions amongst them. As I say, if you've got any questions, please do pop them in the question and answer. So the first question is often and should be, do we need a deputyship at all? Now, I say it's the first question on whether it should be. It's also sometimes quite a tactical question to ask, in that if there is likely to be a huge dispute as to the identity of a deputy, nipping a deputyship application in the bud with arguments which are carefully constructed about the need for a deputyship at all preempts and defeats the argument about who the deputy should be. So the first step is obviously the Mental Capacity Act framework, as I said, leads us towards the least restrictive option, section 1.6. That's one of the principles of the Mental Capacity Act. In practice, that often means asking whether the issues that are being identified as a need for a deputyship could be resolved in another way. And in another way, I mean through a one-off order or a limited, tightly defined order or a limited authority rather than a wide-ranging deputyship. Um, we'll come to some of the examples of that sort of order later in the talk, but effectively it's stuff like whether the Court of Protection could be invited to release funds or authorize a particular action or access some fund that someone has, but very specific, time limited, and specifically authorized things rather than effectively deferring to a deputyship. Um, the court, as you can appreciate and probably all have experience of, will be very uncomfortable in appointing a deputy where the protected party has very limited money, where that money comes from a very limited route, and the usual situation is where the money will comes from benefits. And also sometimes the court can be uncomfortable where there's no complex investments or assets. So where it's a simple estate and where there is a clear question that needs to be answered, i.e., could this be dealt with in a more simple way? The court may not want to appoint a deputy. And in those circumstances, the court might consider that the supervision fees that the OPG charges, the fees that the professional will charge, and other costs that soon rack up, including the costs of the litigation, become disproportionate. So the framing should become, is actually the application for deputyship a genuine long-term need, or could it be solved by one of the discrete orders that I've already described? As I say, asking that question early on is tactically helpful, but also necessary because it's required by the Act. I think I've skipped one. Yeah, so the as I say, from the tactics, that's a useful approach. But how do you do that? So, as I say, when arguing about whether deputyship is necessary, the specific facts of the case and therefore the evidence is everything. What I would suggest is having a clear schedule of assets and income, confirmation about what the person's benefit situation is, and identifying the exact transactions or issues that need to be managed are sort of essential if you're going to make a submission to the court that actually deputyship isn't needed. Um, and if that's the case, the submission should really focus around how simple the finances are, and how time limited this involvement would need to be. So clearly, if there isn't a need for a deputyship, that's an argument you can make. But the court might still be concerned that this person needs some assistance. And the way that you therefore ameliorate the court's concerns is you come up with submissions or evidence the submissions as well, about how risks are going to be mitigated. So if it is a time limited and a specific authority in a court order, having some response to the question of, well, deputyships are regulated and also there's security bonds and protections, safeguards. What are the safeguards in this creative situation? Having an answer to that question, having an answer to the practical reality of who holds the money and what reporting that would have to happen. So if it is the case that you want one specific thing and you want someone authorized to do that, for example, a local authority to take one action, then there might be a need to respond to the court to say, well, we'll report back by way of a witness statement once that's been done, or something. But in effect, that defeats the need for a deputyship, but gets you what you want. And as I say, it can be quite tactically advantageous because you don't then get to the situation of arguing about who the deputy should be. But anyway, Arianna is now going to talk through one of the situations, I think, which is this sort of situation, which may be addressed by one of the targeted orders that I talked about, as opposed to deputyship.
So, thank you so much. What I'll just be talking about now is child trust funds, because this has been an issue which has been both in the news and increasingly coming up for a lot of families. As I think many people are aware, there were a huge number of people who invested in child trust funds, with some certain funds being given by the government in the 2000s, but many families also added to those in order to have a savings pot for their child when they turned 18. The fundamental difficulty that a lot of these families were having is that when the child turned 18, there was no real way of accessing those funds other than by applying to a deputyship. There have been a number of solutions which have been implemented to try to make it easier for people to get deputyships for their children in these sorts of cases. And there's a fee waiver for people over the age of 18 who have assets of less than £4,250 and income of less than £1,420 a month, so that that's an easier fix for people to get access to these child trust funds. People can also apply for exceptional fee waivers in the event that that the child has assets greater than that. One of the reasons I wanted to bring this up, though, is because I think it's sometimes an interesting thing to happen where the amount of the child trust fund may be really limited and the person's assets may be really limited. And I think one of the questions that might be worth asking in those cases is, do you actually need a deputyship? And is it actually proportionate for someone who, in all of their circumstances, say for this one particular pot of money, would be able to be looked after by an appointeeship? I think one potential solution that could be looked at in those sorts of cases where you've got parents who are involved in the person's life, there are no financial safeguarding concerns, and they may already be the appointee for that person, would potentially to be make a one-off order. And as Alex is talking about, the range of different options that can be considered alongside deputyship. So for a person for whom appointeeship would be appropriate, would it potentially be appropriate for the court to make a one-off order el- essentially releasing those funds to the parent who is already looking after that person's assets to spend in that person's best interest, particularly where this could be a really small amount of money. So in many cases, if the parents weren't adding to it during the child's childhood, this may only be £2,000 or £3,000. One of the areas where I've actually seen this come up quite a few times is around welfare orders in the court of protection, where you have someone who may be tipped just over the legal aid threshold and may really struggle to make those contributions because they can't get access to the child trust fund. So it's essentially this pot of money that's beyond their reach, but preventing them from accessing other benefits. So I think this is a conversation to be had because there are many parents who will want the deputyship and will want to proceed forward with that. But potentially it is a conversation for the parents to consider, would there be another solution to this problem in terms of accessing that fund and then continuing on with the relatively lower weight appointeeship that they could otherwise have. So handing back to Alex to continue on this trend.
Thank you. Um, so the next aspect of the question of deputyship is who should be appointed. If you've established with the court that one should be appointed and the court has either disagreed with you that you could establish or get the same result through a one-off order or other orders, then you have to look at who's going to do the job. We all know that when a deputyship is required, the court looks at all the possible contenders. So the usual contenders here are family members, local authority deputies, professional deputies, and panel deputies. The reminder, of course, is that there's no rigid hierarchy. The court in Re AW back in 2015 established and reminded us actually that nobody has an automatic right to being a deputy, and the court has absolute discretion as to who it appoints. The identity of the deputy is up to the court using a best interest analysis. Since then, other case law has endorsed that approach that there is no hierarchy, which is an interesting approach given that other areas of the Court of Protection would tend to prefer family members because they know P better. But in this instance, deputyships, the starting point shouldn't be family members are best, therefore they should be appointed. Deputyship holds a special place and is an appointment which is on a best interest basis, effectively. Instead of working out a hierarchy, the court should be asking, per the best interests, who is best placed to act in best interests, who is practically able to do it. There might be practical considerations such as if one person is very far away, that isn't an absolute bar to them doing the job, but it might be an influencing factor as compared to someone who lives down the road from P and knows them very well. But practical considerations as to who can do it. And also looking at it from a risk point of view, who presents the least risk to the management of P's financial affairs. So there isn't a hierarchy. It's a best interests analysis, but also some practical considerations as to how the job will actually be done is important. On the question of who does it, one of the key questions that we often get asked is who could we get someone else to do it? And the someone else is usually a local authority. Local authorities, as I put here, will sometimes I put often, no, I haven't. Well, I meant often resist appointment because they are under huge resource pressures. They may perceive it to be a hugely complicated appointment with perceived conflicts between family members that they don't have the ability or the time to get involved in to mediate, or there may be, and this is a bit pessimistic, there may be a want to avoid ongoing responsibility. Um, that isn't a reason for a local authority to resist appointment. You'll all be familiar, probably. There's a very recent ombudsman case involving London Borough of Haringey, whereby Haringey were criticised by the ombudsman for not making the application for deputy or not identifying a deputy. Um, and that caused the protected party in that instance some difficulty. So local authorities can't just step away. The ombudsman in that case and the local authority agreed that they do have safeguarding duties, which may include safeguarding duties over finances, such that they need to have a handle on the appointment of a deputy. But if the local authorities say, no, I'm not going to do it, the Court of Protection can't force them to. And in that situation, often professional deputies will fall back as the default compromise. Um, Professional appointment, though, isn't an automatic uh, an automatic thing that should happen. The court should still be weighing the history of involvement that people have had and the ability of various people to work together. The next slides deal with family members and family conflicts, because that's often a situation that comes up when we're dealing with deputyship applications. But my first point is really where the default often falls on a professional. If a local authority can't do it, that almost gets it the wrong way round. If one person, the preferred option, can't do it, really the questions that the court should be asking is, well, back to the drawing board, who could do it and what the various factors are involving that. So, involving family conflicts. The clearly family conflicts is one of the strongest drivers towards a professional being appointed. We'll all have experience in court where there's two sides of a fractious family, and the court will just very confidently and comfortably say neither of you should be appointed, it needs to be an independent person. Um, and that might be right because choosing one branch of a family over another would alienate one branch, and that makes actually the management of the whole system quite difficult, partly because they can't consult each other per Section 4 of the Mental Capacity Act, but also there may be complaints, there may be an inability to access some funds, that sort of thing. So the workability, if that's a word, of the system and the deputyship falls down if you prefer one branch of a warring family over the other. But it's important to say that not all family contract conflicts justify that outcome. So it isn't the case that just because there is a family drama, if I put it that way, disrespectfully, then therefore there needs to be someone independent. What should happen is early case management should identify what the conflict is actually about. And I think in that situation, separate the financial risks and the management of the protected party's money from emotional dispute and any disputes in a sort of more holistic sense. Because it's only if a dispute were really to impact the management of P's money that it should be used as a reason not to appoint family members. And I appreciate there's case law from quite a while ago now about not appointing disputing family members, but I think that needs to be contextualized with what the dispute actually is, because you risk in that situation costing the protected party unnecessary money in appointing professional, where actually early case management and early identification of what the issues are could resolve that. By early interventions, I mean directions or the use of the dispute resolution hearing to narrow the issues and test what's going on. And as I say, this can save quite a lot of cost for the protected party and the other parties because effective use of the earlier hearings, for obvious reasons, can avoid dispute in the future. Now, I know Arianna has a particular view about the efficacy of dispute resolution hearings, and I don't know whether she'll raise that now
Yeah.
or.
And I think it's just discussing this. I think one of the interesting things, and one of the things that Alice, you pointed to on this already, was that some of the cases on this are more historic. And I think in large part, that's because of the effectiveness of dispute resolution hearings in a lot of these types of cases. The DRHs came in about 10 years ago, and certainly I have seen a great many very effective and very robust DRHs where the judge gives blunt guidance. And I think when people come in well prepared for DRH, they're fully making their cases. And when the judge can give that really strong indication, I think it is something that often makes the family members reflect, particularly where there's a family conflict, is are we able to work together? If we are not able to work together, what is the efficacy of having a panel deputy or professional deputy come into place and to look at the issue in the round rather than having that all spill out. So I think it is something in terms of preparing for these, making really strong, robust cases so that the facts are there to allow that clear judicial indication can really save a lot of time and money in these and resolve that dispute at an early stage if it's clear that someone actually has a good case to be deputy or the conflict is so irreconcilable that it's never really going to work with one of the family members.
Um, Arianna, sorry, while I've got you, on DRHs, do you have a view about preparing for them as solicitor counsel? Do you think putting position statements, how should you th use them?
I think they really are. I mean, I'll say some of the best ones that I ever saw were by experienced cop judges. I think some of the regional lead judges and obviously all the First Avenue House judges do these things all the time. And I think I've seen this insofar as a confident, robust judge who really feels that they've got the full facts in front of them, I think can give incredibly clear indications in terms of where the trajectory of this case is going. I have certainly seen many people come in very confident to DRHs and after getting the judicial indication decide that they need to settle the entire thing because they've gotten that so clear. So I think that is something in terms of preparing for these hearings. If you do have a good case, if you have someone who is a credible deputy, who has a solid plan forward, making sure that that's really well framed for the judge from the DRH perspective and actually putting in some good preparation at that point in time, because I think that's a really good opportunity. I think, as Alex, you're saying, to try to nip these things in the bud rather than let them spill over. Because I think for a lot of the cases, the concern will be if we let this go into a full contested hearing, this is going to cost P, you know, tens of thousands of pounds. This is going to be very, very detrimental in terms of fomenting family conflict, as opposed to going into the DRH and walking out 3 hours later with the deputyship order, I think is often something that it can actually end the conflict and it can provide a really good template for the road forward. So I suppose in our overall talk about having contentious deputyship hearings, one of our central pieces of advice is trying to avoid those contentious deputyship hearings by coming at it early, coming in strong, and getting it done at the DRH, which I think can often be a really effective strategy.
And I think the next slides are about situations where that didn't happen and there
Where that
was an
didn't
ongoing
happen.
conflict.
And
Over to you.
interestingly, a great many of them from prior to the DRHs being implemented. I'd also note that I'm going to take you all through a couple of cases. Several of these are from Senior Judge Lush, so they are older cases that are not necessarily the way that the current Court of Protection would see them, but there are some interesting authorities and I think give some interesting case studies. One of the other points that I would take out of quite a few of these cases as well is that many of them are really very fact specific. And I think the court is trying to drill down, and a common theme for all of these is, can this work? Is there actually a path forward where someone in P's family can be looking after them? The first couple of them were cases where that wasn't really going to be the case. So in this case, this actually started off as an LPA removal. And P's two children in the case had a joint and several LPA. They didn't get along or trust each other, and they'd each made complaints about the other one to the OPG. One sought to revoke the attorneyship and become a sole deputy. So they were bringing an application to the cop to become the deputy. The OPG said this should be a panel deputy, not the family member. And what Senior Judge Love said in this case was that the LPA wasn't functioning because of what he referred to the corrosive effect of the animosity between the attorneys, which has created an impasse in the management of Yale's affairs since at least 2012. Things weren't getting purchased. They weren't getting bought. And the court declined to appoint the former attorney because he said that it was partly, if not primarily, responsible for the breakdown in the relationship between the attorneys in the first place. I think this is just a good example of the traditional view on this. And I think the way that the court will often see these sorts of things, particularly where you have two siblings, there are not any fundamental safeguarding concerns about either one of them. There is no reason that they should not be involved in P's life, and they simply cannot get along whatsoever. In those sorts of cases, the the first line of that everyone is going to be asking is, why not a panel deputy? Why not look that forward? And I think one of the things we'll be looking at in some of the subsequent cases, there may be some good reasons for that. If you do have someone who is a competent deputy in and among the family members, it may be more beneficial to P to look at. We'll look at another case, which again, fundamentally similar. I won't lie, but I think again it gives a bit more of the traditional example. P's two children, joint holders of an EPA, and they quote unquote detested each other. And that is the court's language rather than my own. And then also a major probity issue in this, in that one had attempted to falsify the EPA document by changing the attorney status from joint to joint and several. This was proven because they had filed a new page of the EPA, which didn't exist at the time that the EPA had been made and was on a different form. So it clearly had been completed some considerable time after the fact, and there was no real doubt that this was something that had been attempted to be falsified. The court made very, very clear findings that the person who had dishonestly attempted to undermine the EPA was unsuitable. Unsurprising finding. But what it was also noted in this case, again, in terms of a family dispute case, the court found that they were both unsuitable to be deputies because of the, quote, intense acrimony between them, and that a panel deputy was essential. Given the court's findings, the sibling would try to frustrate the work of the other. But again, I think this comes back to the practicality of it. The court's finding is not necessarily that in all cases where there's a family dispute, that you can't have one of those people be the deputy. The court's finding is it wasn't going to work in this case. And I think, again, that's certainly been my experience in the DRH, is that's the question the court is asking is, can this work? Is it possible, or is it all just too far gone at this point in time? And I think that's something that's very much in nature of a matter of degree, a matter of the personalities involved, and trying to put forward a cogent case for why one of these individuals might actually be able to make it work practically on the ground, which I think also depends in some cases, and you'll see this in some of the other ones, that the relative involvement of the proposed deputy in P's life is also an important factor, particularly around P&A issues. If you have one person who is on the ground, seeing that person regularly, even if they don't get along with their siblings, it might not be necessary to be consulting with their siblings regularly on these sorts of cases, particularly if they are a deputy. And if they are able to hold the ring and actually get the job done on a day-to-day basis, the acrimony between them may not necessarily be prohibitive. So we'll go on to the next one, which again, you may see a bit of a theme on all of these, but this is again a Chancery Division case. And again, I think this is interesting, and it again goes to the really fact-specific one, but it's an interesting authority, particularly because this was upheld by the Court of Appeal. And again, an older case, so not necessarily indicative of all of the current thinking of current Court of Protection judges, but an interesting authority in terms of it's talking about the unsuitability of hostility between the three children. The master considered that that fact alone rendered any one of them unsuitable to be Mrs. W's attorney. In my judgment, such hostility may well have such consequences, but it depends on all the circumstances. For example, had the estate of Mrs. W been complex and had it required strategic decisions in relation to its administration, one would expect the attorney to have had to consult and work with her siblings in relation to the administration. In such circumstances, the evident hostility between them would impact adversely on the stewardship of the attorney, no matter who was at fault in creating the hostility. But if we go on to our next slide, please. For an opposing view, and again, this is a case called Rief, they noted that it seems to me that to remove a chosen attorney because of hostility from a sibling or other relative in the absence of any effective challenge to his competence or integrity should require clear evidence either that the continuing hostility will impede the proper administration of the estate or will cause significant distress to the donor, which would be avoided by the appointment of a receiver. And again, I think this goes back to the central question: it is really fact specific. Can someone get the job done? And I'll say certainly in my own cases, I have seen things where multiple siblings are entirely at war with each other. They cannot get along, either in terms of all of the siblings or in terms of camps of siblings. But there is one sibling, often someone who is very involved with P, very much involved in their life, who may be able to entirely competently pay their bills, particularly for people who are potentially living in care settings. There may not need to be these sorts of complex decisions made about the administration of their state. What they need is someone who will be able to buy things, who will be able to pay bills, who will be able to check on them, who will be able to make sure that they get what they need. And the fact that your siblings hate you may not be prohibitive to any of that. This may be something that you can execute without necessarily those sorts of consultations with your siblings on a regular basis. And you would really only need to talk to them about some of the big picture issues, such as decisions to sell houses and that sort of thing, which generally requires further authorization from the court of protection in any event, and is often going to be very much driven by the person's financial needs. So I think it is something that's really important to look at in terms of not necessarily giving up at the first hurdle just because there's a family conflict. It may well be the case that you have someone who can do the job and frankly save P quite a lot of money if they are able to do that without the appointment of a panel deputy. Because again, I think there's often a really strong desire to avoid the cost of a contested hearing. But looking at the other side of that, the cost of the appointment of deputy, even of a deputy just getting up to speed with the entire file, may be really significant. And if you have someone who does not necessarily have a huge or complex estate that requires professional administration, or the family member who's being proposed is someone who potentially has a relevant background, they're involved in business, they're involved in accounting, they're able to fully manage someone else's money in that way, that may be a really good option for P in terms of looking at the relative value of that. We're going to talk a little bit more towards the end of the talk as well about trying to have proportionate final hearings as well, because I think this is also something that there is this fear in terms of, well, we don't want this to just cascade into this very expensive dispute. But I have certainly been involved in contentious deputyship disputes between families, which have taken place in a single afternoon. And I think that is very possible if you are not involved in one of those major sort of safeguarding allegations, and if there is a relative clarity in terms of what P's capacity is in those sorts of cases. If we could go on to the next slide, something else, this is again a bit of an older case we're looking at, but an interesting one insofar as it looks at if you have family members who are estranged from P, the needs around notification. What I would certainly say is my experience in the last few years has been that there is a big push to make sure that there is robust notification of relevant people in terms of 3 people being notified. This was a case, again, from longer ago. This is now more than 10 years ago. But this was a solicitor who had sought deputyship for P at P's request. P had asked the solicitor that 3 of her 4 children not be notified because they had been estranged. Some of them lived out of the country and she was not in touch with them anymore. One of them had physically assaulted her, one of whom had suffered very serious brain injury in his own right. I'm so sorry. Can we just slide onto one slide? Thank you so much. One of whom had suffered very serious brain injury and didn't have capacity in his own right. And the son, specifically the one who had assaulted P, made an application. The deputyship order was granted just on the papers by an ACO. One of the sons who had not been notified, GN, had sought deputyship and setting aside of the order on the papers to appoint the solicitor as the deputy. And what he said is essentially, well, I should do it. I'm her son. I'm closer to him. And what P said was that he had acted very inappropriately towards her. She didn't want him involved. He assaulted her and he had stolen money from her. And what the court found in this case was that the solicitor had acted appropriately in declining to notify him in this case. Now, what I would say certainly now, if there is any sort of view to exclude P's close family members, such as their children, from any sort of deputyship application, I would always make that in advance and on the papers to actually set out the reasons why that non-notification would be happening. Because I think if that's not made, I think that's going to be an immediate red flag for anybody reviewing that deputyship application. But what I would also say is I think this is the sort of case that provides a really good example of why P's family may not necessarily be the right people to be involved. This is a person with really obvious safeguarding concerns. P herself did not want him involved. Again, criminal issues in terms of abusing her. And the real question is, why should P be spending her money to deal with his deputyship application, which is obviously inappropriate on face, and where she had appointed someone who was appropriate and able to do that? So I think, again, sort of another side of this in terms of, do you actually need to have this conflict at all? Or is this really something that is so baseless on face that really the deputyship can proceed without this person being involved? One final case I'll talk about is the Combly case, which is an interesting one, again, in the context of family dispute. Really interesting case in terms of a young man, P, who is still a child and still living with his family. He had received a very significant PI damages award, and they were in the process of renovating his house. P had already had multiple deputies over the years, the most recent of whom was Mr. Combly. And the deputy considered that the family members were deliberately causing a breakdown in their relationship with him in order to have a deputy who would accede to their own wishes in terms of what they were doing with the house and the expenditures which were being made. Initially, there was co-contest around the discharge of the deputy, and the court looking really closely at the circumstances under which the deputy ought to be discharged and whether that was in P's best interest to discharge him. The father and mother both suggested that they should become the deputies in this case, but the father had a conviction for fraud and was unsuitable. And the mother was considered unsuitable because she was not really taking a position that was critical to dad in this case. And I think there were a lot of concerns around how dad was conducting himself around the deputies. And she did not appear to be able to be independent in terms of dad pushing his wishes on her in that particular case. But the court did come up with an interesting solution because after, if I can go to the next slide, after a series of deputies who had not actually been able to get things off the ground, and P incurring cost after cost after cost as each new deputy came on board and things did not work out well, would have to do all of their own due diligence, then make an application for discharge, appointment of new deputies, cost of new deputies coming on board, and a real concern from Judge Hilder that this was not really serving P in the long run. The mother and father in this case had put forward more distant relatives who were anonymized as KS and AQ. And what the court looked at were a couple of factors in that case. Is one, the building on the house had essentially completed, and that had been a really focal point for the tension between the family and the deputies in terms of the family wanting the house bill to take place in a certain way. That was now coming to an end. It was also viewed that the two relatives were more likely to have the dad's cooperation in the matter and they also wouldn't incur management fees for P. So essentially, when they came on board, their due diligence would be done at their own cost rather than being done on a professional basis. And hopefully there would be less conflict between themselves and dad. But Judge Hilder also noted the disadvantage insofar as they didn't have experience or indemnity insurance. So what the court did was make a really targeted order in this case to try essentially a new solution after multiple deputies had been attempted and had not been able to come forward with a reasonable, workable solution, where again, it was entirely agreed by everyone that it was very much in P's best interest to remain living with his family, and they were going to be a massive part of his life going forward. And what Judge Hilder did in that case was, if I could just go one slide ahead, oh, thank you so much, appoint a number of different steps to mitigate the potential risk. She appointed them jointly, so the two relatives would have to agree on the decisions that they were taking. She proposed to take steps to ensure that the budget set would be complied with and further funds could not be withdrawn. The court required the deputies to make a further application to the court in respect of any dispute with the dad, which wasn't resolved within 3 months. Their appointment was time limited to allow review after supervision by the public guardian. They were required to hold a £400,000 security, and they did not have authority to sell the property or withdraw from investments. So this is obviously an unusual case in many ways, but what I think is interesting about the case is that rather than having multiple failed panel deputies and trying this yet again, the court came to it again with some realism in terms of saying that the panel deputy model really did not seem to be working for this family and having a willingness to try something else. And I think that again goes to the sort of creative problem solving and really fact specific nature of a lot of these sorts of disputes in looking at what is going to work for P and is there some solution, even if it's outside of the norm, even if this is coming with quite a lot of guardrails in this particular case to see if it works, but trying something that hopefully would break the impasse which had developed and appointing these deputies in that context. And now I will pass back to Alex to talk about issues around contentious final hearings and how to look at those.
Sorry, the slides keep skipping on because I keep touching my mouse. I'm not trying to skip you along, but thank you, Aaron. I think from that, two things jump out at me when I get to the final hearing is just how much discretion judges have to make the decision about who should be a deputy and whether a deputy is needed. You'll have experience, I'm sure, of being in different courts and getting a different answer depending on which judge and on what day you get them, potentially to the same fact. So it's worth bearing in mind that when collecting evidence, it really needs to be quite convincing for a tribunal that will have to make a decision not based potentially on a rigid framework, but on what their feel is for the case. But more importantly, I think from what Arianna was just saying, is this aspect of judges having discretion about creative deputyship orders. So what powers they can give to the deputy and what safeguards they put in, that might be a convincing line of argument if the court appears concerned about a wide-ranging deputyship order, and that being the end of the story. Some sort of arguments about there being more creative approaches might be helpful. Then we come to the final hearing. You've had all the directions hearing, the dispute resolution hearing, nothing's worked. I wanted to pull out one aspect of a final hearing because, of course, any final hearing will depend on the facts and there'll be different aspects of it. But one aspect we haven't really talked about very much is capacity. And capacity disputes often increase complexity, particularly in deputyship applications, because the capacity to make decisions about your property and finances is quite complicated. It's hugely personal and can vary based on the person. So all I would say about this is it's important, and this sounds obvious, but is missed, to identify any capacity issues at an early stage so that the evidence can be built up in an appropriate way. I say this and I say it's obvious, but I've also seen it being used as a tactic to strengthen parties' positions on appointment of a deputy, i.e., not being raised at an early stage, but rather noticed at a stage later in the proceedings, and that would be wholly wrong, I think. So even in a dispute resolution hearing, it's quite easy to brush over the deputyship capacity rather point if actually there are wider issues like is a deputyship needed at all, but it's worth bearing in mind even at an early stage you need to determine and have clear in your minds as to where you're going with capacity. Um, and as I say, dealing with those issues early on and considering what expert or any evidence you might need on capacity. Um, the other point is how you structure the final hearing. So again, it'll be completely case specific, but I found that actually framing the hearing in a certain way can take the heat out of the fire often. And I've called it a beauty parade model. What I mean by that is rather than positing it one party versus another, which is quite an adversarial approach, having it potentially in a position statement as a list of options with pros and cons, such that you have the beauty parade of the options, and then working out which is in her best interests to be appointed as deputy, her or him, obviously, for the protected party to have as their option. That somewhat, excuse me, takes the heat out of the fire, it reduces hostility because it's really then a question of best interests rather than a question of one person winning over another, particularly where it's a warring family. And in that way, may in fact lower the temperature of proceedings if actually it's a question of the best option rather than one option being a possibility and another not being a possibility. Clearly, that's only relevant and possible where you've already narrowed down the issues to being the options that actually exist. If one party is saying that this person can possibly do the job because X, Y, and Z, that might be the argument you have. But where it is literally an option between X or Y, literally framing it as a choice in that way is sometimes helpful. Um, I know, Ariane, you promised that you'd come in on the sorry, the no, on sorry, I'm giving yeah, on
Yep,
final
jumpy
hearing. Did you
slides
have
today.
yeah,
Yeah, and I think I'll just say, I mean, I've had beauty parade sort of styles, both in terms of written submissions and oral submissions for both family members and for professional deputies. And I agree with you, Alex. I mean, I think that does work really well because I think it sort of refocuses it in, particularly if you're looking at multiple professional deputies, there is no reason to spend lots of piece money on those sorts of disputes. And I think that's something the court is generally very amenable to because what you're talking about are competent people. And I've seen this sort of decided on the basis of two-page written submissions, and everybody puts it in, the court decides, and we all stop spending money, and P gets on with their life. And I think that is something, again, in terms of the contentious deputyships, is everyone is always very keen to avoid a contest on these sorts of things, which I think is entirely right, because obviously if there is any consensus which can be reached, then that's going to be the best thing to do. But I think it is also important to look at it in the context that you can make these hearings really proportionate and you can try to narrow down these issues such that you are actually just moving on and making progress for P as soon as they can. Um, where sometimes this can become more challenging, though, and I'm going on to the next slide, is where P is the one who is objecting, and that can be really tricky. In terms of P, I've had a number of cases where I've been involved in where P is the one who is objecting. One of those, the call is coming from inside the house situations. And I think these can arise for a number of decisions. We'll talk about the Riddle case in just a moment, but there are certainly many cases where P objects to the finding that they lack capacity. There are many cases where P disagrees with the appointment of a deputy, but the first stage in a lot of these sorts of things is to think about what P's participation is going to be, and that's something that's got to be flagged up to the court at an early stage under Court Protection Rule 1.2. I've certainly seen many cases where P seeks to be a party to the proceedings, and the issue that always arises really quickly in those cases is, does P have capacity to conduct the proceedings for themselves? And if not, is there someone who can suitably act as a litigation friend? Um, I think, unfortunately, often what you often find yourself in this situation is that there is no one who can act except for the OS. And when you get into those sorts of scenarios, the cost to P immediately skyrocket in those sorts of cases. So I think this is, again, something where the court has to look at that in terms of the P's Rule 1.2 representation. And usually what I've seen is in the first instance, the court just tries to gather some more information about what is P's objection to the case. Are they objecting to capacity? Are they objecting to best interest? And is there some way for the court to deal with that other than P being joined as a party? Because that's inherently going to add cost to proceedings really significantly. And it is not mandatory that just because P is objecting that they need to be made a party to the proceedings. And that's something the court would have to look at in terms of what P's participation was going to be, particularly if they lack litigation capacity. And if they don't lack litigation capacity, there's probably a bit of a head scratching in terms of, well, do they lack property and affairs capacity? Because in general, I would say the person is able to litigate proceedings around property and affairs. It's not entirely clear why they're able to do that, but not make those decisions for themselves. In terms of going on to the next slide, if we go on to the next slide, just in terms of some practical solutions that I've certainly seen, the notification of P, I think, often creates a really good opportunity to do this because obviously, with any deputyship application, P does have to be notified. They do have to be talked to. And certainly, in a great many I've seen, P is either in agreement with the application for deputyship or does not understand what is being proposed. And obviously, in those sorts of cases, this is a non-issue. But in some of the other cases I've seen, sometimes it's actually really helpful to understand P's views and their positions on the issues in order to determine whether there is some solution that might be acceptable to P. I was involved in one case with a man who did not have significant assets, and under other circumstances, it might have been queried whether the deputyship would be appropriate, but he kept making a series of disastrous financial decisions for himself, one after the other. And there was a view to try to get a deputy in place so that they could undo those disastrous financial decisions that he was making as and when he made them. And he was very concerned about that. And he didn't like the idea of giving up his autonomy. But actually, he sat down with the deputy. They spoke for about an hour. And the deputy explained to him that he would be given a cash card, that he would, continue to pay for all of the things that this man was normally paying and enjoying in his life. He was explaining how he could help to work to support him around the credit card agencies who were giving him quite a lot of chase at that point in time, and how he would support him making decisions in his day-to-day life about the spending money. And after the man had actually had a chance to talk through what a deputyship would look like, he agreed to it. He didn't have capacity. He didn't fully understand all of these issues. But what he was worried about was that this was going to be a total surrendering of his autonomy. And when he was given that reassurance to know what it would actually look like on the ground, he dropped his objection to it, and the deputyship order was made with, again, not his capacity disagreement, but in accordance with his wishes and feelings in those sorts of cases. I've also seen other cases where, again, a local authority may be seeking to become a deputy, or a panel deputy is being appointed, and there's someone else who can come forward. And I think those sorts of discussions with P can be really helpful, because if there is somebody that P trusts, that can again avoid a really sticky situation in these sorts of things where P may otherwise be objecting. But if the deputyship is going to be vested in someone that they have confidence in, they may be much more comfortable with that and stop their objection. So I will pass back to Alice for our last couple.
I'm aware that I've asked everyone to use the question function. You've been doing that. One of the questions I think might be helpful for this point is about P's wishes and feelings and how important they are when there's a family dispute. And obviously, Arianna, you've dealt with the situation where P has particular views about the application itself, but do you have anything further about the
I,
family
I
dispute?
think it's I think it's interesting because I have to say in cases that I've been involved in, I've not often seen P's wishes and feelings be necessarily decisive. I think one of the issues, again, kind of coming back to this overarching theme of practicality and a lot of this stuff, is that if it means that the deputy is going to have a better relationship with P because P likes them and trusts them, I think that can potentially be decisive. But in the family disputes, um, I don't know how much it swings it, because I think often there is a concern in a lot of these cases that you don't necessarily want P to be getting pressure from family members one way or the other to be saying, I support X or I support Y. And I think often it's somewhat discouraged to try to be bringing P into those sorts of family conflicts. I think if P is making more spontaneous comments, I think that often goes a lot farther. And I think one of the questions that's often raised is, if some independent person is talking, if they have talked to a general visitor, if they have talked to the care home provider where they work, and they have spontaneously expressed those, I think those carry more weight. But I think often there's a lot of this is taken with a grain of salt.
I agree. Um, the last aspect then, before we sort of wrap up and answer any questions, is around costs. And it goes without saying, contentious applications generally, but especially deputyship applications, are expensive. Um, the first point, therefore, is advise against, please, and we do, the use of property and affairs deputyship applications or property and affairs applications more generally as a proxy for safeguarding litigation. A court of protection money application involving a deputyship application isn't really the forum, I would say, for aerating family disputes or particular disputes or concerns that families might have about safeguarding issues. There's a lot cheaper routes for them to do that, and also easier and more appropriate routes. So ensuring that the correct application is being made to the correct court is the obvious one to first step to sort of mitigate against the cost risks and the inevitable costs. Um, the other point is making sure that the appropriate applicant is the one that issues proceedings. It's very expensive to put a case together, as you know, and also to bring a case through the court, even if it gets only to the dispute resolution hearing. Making sure you've got the correct applicant is important. As I say, I said before, a local authority might be the appropriate applicant given their safeguarding duties to a protected party. Um, it's often useful to approach the local authority if that is believed to be the case. And as I say, they do have a duty to be looking at this sort of stuff seriously. Um, if you're a family member with or acting for a family member with concerns about how someone else is acting, the first step might indeed bring it to the local authority's attention. I appreciate that may not be a quick route, but just because you bring the application doesn't mean you have to be the applicant thereafter. It might be that part of your application is to remind the court or the local authority who you notify of the application that they should be the applicant, and that might be part of the directions that you're asking for initially to replace you as the applicant. Um, Having said that, there is also a risk about acting prematurely in making an application. As I said, property and affairs applications shouldn't be a proxy for safeguarding concerns if actually there are more appropriate routes. So there is the danger and the risk of the cost risk, as it were, of jumping the gun on an application which should have been made only after other steps are taken. And I turn then to the recent case of the Riddle case, which illustrates a particular risk that deputies, albeit Mr. Riddle being a professional deputy, not a solicitor, not a panel deputy, as it were, encounters. So the professional deputy, being Mr. Riddle, applied in this case to be appointed as the protected party NA's property and affairs deputy. There was a COP3 with the initial application saying that P lacked capacity to make decisions about managing their finances. That COP3 was later overturned, as it were, by a Section 49 report, which said that P did have capacity. And the application was eventually dismissed, as it were, for lack of jurisdiction because P had capacity. Mr. Riddle accepted the Section 49 report, and the question was at the end, well, what happens with the costs of this application? In the first instance, Mr. Riddle didn't get his costs. The Mr. Riddle was seeking around, I think, £10,000 in costs from NA for the purpose for bringing the application and for taking it through the stages, which led eventually to it being dismissed. So in the first instance, no order for costs, and Mr. Riddle didn't get his costs. It then went to an appeal, and the appeal judge agreed with the lower judge and said, actually, no, Mr. Riddle shouldn't get his costs. I think it's fair to say that the appeal judge said that even where an applicant acts reasonably and in good faith, the court may still depart from the usual cost starting point. So there is a reminder that there is an absolute discretion given to the court about who to appoint for deputy, whether to appoint a deputy, and also then it comes to how to remunerate people for bringing this application. The judge said it may be unjust to require a successful, vulnerable adult, so in this case, NA, who was successful in saying that he didn't need a deputy, to pay for, I think the words were, a professional stranger, their costs in a case where NA didn't want a deputy and was resistant to having one. So the court in that instance balanced the fairness to the protected party and also the commercial risk, as it were, to professional deputies, being a solicitor or otherwise, of bringing these applications. And I think this case really highlights the real risk of costs in deputyship cases, such that what I've said before about choosing the correct applicant, making sure the steps before an application that can be taken are taken, and actually making sure that you focus minds at the first and earliest opportunity about what the dispute may be and try and kick it out at that stage. None of that is surprising because no one wants costs, but I think particularly in the Court of Protection, where costs are unusual in that sort of case, there is a real risk of costs, and the costs are highly discretionary in the Court of Protection. The last slide then just turns to the practical guidance that we'd suggest. And I'm going to try and, oh, there's 6 questions. Thank you. But we'll save time at the end for the questions because I can't currently read them. So the red flags, I think, in a property and affairs application are clearly, I've already summarized what the aspects are. I think the takeaway points from me at least are early questions to ask the client around is deputyship needed, who benefits, and what does P actually want? And also to have some mind about protecting yourself, so cost warnings to the client, and defining the scope of what the court might actually be able to achieve is super important. Um, and if I may, the last thing is an obvious thing, but I always try and put these in. Good evidence is so important. We need to remember, of course, that court of protection judges are lawyers who have come in from other jurisdictions like family or even the court of protection or private client work. They will be familiar with forensic type of evidence. It's not helpful, I would say, to have highly emotional evidence in cases like this. It needs to be borne out. The facts need to be quite clear so the court can be clear as to what decision it's being asked to make and on what basis. So good evidence, cost warnings, and defining the scope of what the court can achieve. Hopefully that will give you a good chance of getting a good result in a deputyship application. But back to Arianna, and I wonder if we've got time for questions.
We've got time for a couple of questions. So we've got two questions that are similar. One is about guidance in case law to assist with the completion of assessment, and another question of is there any reason why the COP has never made an attempt to set out the likely relevant information in the context of property and affairs capacity disputes? With that person making the very uh, sage comment that whilst every decision is unique and of course very personal, it would be incredibly helpful for frontline professionals if the COP outlined what would likely be relevant and irrelevant in the context of property and affairs. I don't disagree with that comment in the slightest. I think that would probably be very useful for people. One general comment I would make about precedentless is though in the wake of the JB case a few years ago, I think what is clear in terms of the Supreme Court's guidance in that is that any precedent list is only ever going to be a starting point. I recognize it would be a very useful starting point for a lot of people to have, and having a starting point at all versus not having a starting point is a very different position to be in. But what I would say, and I think this is possibly one of the reasons why there hasn't been a reported case having this is what it means to manage property affairs is precisely for what the question asks is because people's property affairs are different. One of the things that JB talked about, and I think is as a guide for all capacity assessments, is around the need to look at the person's particular circumstances and the consequences of making decisions one way or another, and what your personal circumstances are in terms of how much money you have, how complex it is to manage, what sort of risks and demands you may face on your money are probably going to be very specific from person to person. I think there's common themes, certainly in terms of the basic numeracy of money, the understanding of bills, incoming and outgoing, and that sort of thing. But there's always going to be something in your particular circumstances that mean, again, if you have very small assets, very simple expenditures, it may be more likely that you have capacity than someone who has much more extensive assets and is more potentially vulnerable to financial safeguarding issues. One thing I'd also say in terms of guidance in completing the assessment, there is the 39 Essex Guide to Assessing Capacity, along with our wonderful suite of 39 Essex resources on capacity. So the capacity guide gives a lot of pointers in terms of conducting good capacity assessments and brings in some of the more general case law and some of the important principles to look at for anyone assessing capacity in property affairs or in other domains. We've got a couple other questions that I'll throw out and I'll just put to Alex whether you'd potentially like to look at these. One of them is whether we had experience on the creative approach taken in Combly being used in practice. For example, provisions for a review where there was doubt about an otherwise qualified deputy's ability to manage certain aspects of P's property. I have seen some similar to that. And I've never had one that was as extensive as Combly, but I have had ones where they were for a more defined period of time and had really significant reporting requirements where people were giving someone a chance, but not necessarily wanting to trust them in the way that you would normally trust a deputy. As would you have anything to throw in terms of creative approaches?
I think the two creative approaches I've seen is a creative use of the security bond and setting a high one. That's an increased protective safeguard, and also time limiting deputyships such that you have to come back to ask to extend it and therefore justify what you've done. Those are the two situations I've seen most frequently. As I say, not as wide ranging as Cambly, but those two can be quite effective because it also focuses minds.
And then our last question that we have for now is whether we have any general guidance for interim orders in relation to disclosing P's finances. You can definitely always go for an investigation and report order, which is one of the standard orders that can be given out by the Court of Protection for somebody looking into deputyship, which is again really common for someone where there is prima facie evidence that they lack capacity on that, but you're not able to complete a COP 1A form at that point in time. So the INR order can be really helpful just in terms of tracking down what their information is from financial institutions. I've certainly seen that in the context of older adults who may not have disclosed their finances to anyone that they trust in their life, but it is strongly suspected that they may have significant resources, and that all needs to be tracked down because it's strongly suspected that they need a deputy. So I think that's often a good step. I mean, I think certainly in the financial safeguarding context, that's important. And I think it can often, particularly in circumstances where there is some very real risk to the person right now, I've certainly seen that being very effectively used to secure the person's position while you are going through that evidence gathering process that Alex was talking about. I think that was our questions for now. Alex, are there any other points that we should cover before we wrap up for the evening?
I don't think so, other than, again, reminder, we've been told to direct people to the 39 Essex website, which we've already done, and also to our excellent LinkedIn page. So thank you for that, but nothing further from me.
Thank you all so much for coming. We'll wrap up now.